Hello, beautiful people. Welcome back to our channel. Right now, Aloy Ejimakor, the lawyer of Nnamdi Kanu, who seems to be handling the other part of his case, especially international case, of course, is being led by Presidency. Today, some hours ago, actually decided to give, should I call it an alarm? He has started filing a suit against the federal government, a monetary sum demanding very huge demands he's making. And it's mentioning one of the things that caught our attention is the fact that he's mentioning medical health of Nnamdi Kanu, which is worrisome. A lot happened in Abia State today that got a lot of people to wonder, is there more things meet the eyes? We're going to find out everything. He wrote the letter, the suit he filed against the federal government, and on behalf of Nnamdi Kanu, and what is at stake right now. Quite a serious issue. Before we go into the newspaper, like and subscribe to our channel if you have not done so already by clicking on the red subscribe button beside it. You see a bell notification icon. Please, by all means, go ahead, click on it to get notified as soon as we update our channel on YouTube. Let's go straight into the news. There was tension in Umuahia, the Abia State capital, on Tuesday as Aloy Ejimakor, lawyer to the detained leader of the indigenous people of Biafra, Nnamdi Kanu, heads to court over the latter's health issues. My God. It was gathered that access roads to the court were blocked by truckloads of the military, police, and other security agencies, which created fear in road users in Umuahia. Ejimakor, in an application, Nnamdi Kanu versus Federal Government of Nigeria, and 7 others brought an expert order asking the court to, among other things, make an interim order of the release of Nnamdi Kanu to attend to his health in any medical facility of his choice in Nigeria, pending the hearing of the motion. The lawyer also asked for the substitution service on the motion on notice of 3rd and 4th respondent. However, the High Court, presided over by Justice K.C.J. Okereke, refused the application and asked the lawyer to put the respondent on notice. He granted the application for substituted service on 3rd, 4th, 7th respondent and adjourned till September 21 for a hearing of the motion on notice. Responding to inquiries in Umuahia, Ejimakor said, "Today I secured an order from the High Court of Abia State to serve by substituted means an application for enforcement of the fundamental rights of Nnamdi Kanu, which I recently brought before the High Court of Abia State. The next hearing date is set for the 21st of September 2021 in Umuahia. The material issue is the unbroken chain of infringement that begins with the 2017 extrajudicial attempt on Kanu's life in Abia State, his involuntary flight to safety or exile, his abduction in Kenya, and his extraordinary rendition to Nigeria. We believe that these supervening issues have complicated Kanu's prosecution and thus must be judicially dispensed with before any further prosecutionary action can proceed. Accordingly, I have placed the following relief before the court." I quote him. Number 1, a declaration that the military invasion of the applicant's building and premises at Isiama, Afaroku-Beku, Abia State on the 10th of September 2017 by the respondent or their agent is illegal, unlawful, unconstitutional, and amounts to infringement of applicant's fundamental rights to life, dignity of his person, his personal liberty, and fair hearing as guaranteed under the pertinent provisions of Chapter 4 of the Constitution of the Federal Republic of Nigeria 1999, hereafter CFRN, and the African Charter on Human and People's Rights, Ratification and Enforcement Act, hereafter the Charter. Number 2, a declaration that the arrest of the applicant in Kenya by the respondent or their agent without due process of law is arbitrary, illegal, unlawful, unconstitutional, and amounts to infringement of the applicant's fundamental right against arbitrary arrest to his personal liberty and to fair hearing as enshrined and guaranteed under the pertinent provisions of CFRN and the Charter. Number 3, a declaration that the torture and detention of the applicant in Kenya by the respondent of their agent is illegal, unlawful, unconstitutional, and amounts to infringement of the applicant's fundamental right against torture and to fair hearing as enshrined and guaranteed under the pertinent provision of CFRN and the Charter. Number 4, a declaration that the expulsion of the applicant from Kenya to Nigeria by the respondent or their agent and the consequent detention and planned prosecution of the applicant in charge number FHC/ABJ/CR/383/2015 Federal Republic of Nigeria versus Nnamdi Kanu is illegal, unlawful, unconstitutional, amount to infringement of the applicant's fundamental right against unlawful expulsion and detention and to fair hearing as enshrined and guaranteed under the pertinent provisions of CFRN and the Charter. Number 5, an order of injunction restraining the respondent or their agent from taking any further step in the prosecution of the applicant on charge number FHC/ABJ/CR/383/2015 Federal Republic of Nigeria versus Nnamdi Kanu pursuant to said unlawful expulsion of the applicant from Kenya to Nigeria. Number 6, an order mandating and compelling the respondent and the agent to forthwith release the applicant from detention and restitute or otherwise restore applicant to his liberty, same being his state of being as of 19th June 2021, and to thereupon repatriate the applicant to his country of domicile, that's to Britain, to await the outcome of any formal request the respondent may file before the competent authorities in Britain for lawful extradition of the applicant to Nigeria to continue his prosecution in charge number FHC/ABJ/CR/383/2015 Federal Republic of Nigeria versus Nnamdi Kanu. Number 7, an order mandating and compelling the respondent to issue an official letter of apology to the applicant for the infringement of his fundamental rights and publication of said letter of apology in 3 national dailies. You are telling the federal government to do that to you. You know that they will not do. Let's continue. Number 8, an order maintaining and compelling the respondent to pay the sum of 5 billion naira, 5 billion naira, not million, no, 5 billion naira to the applicant, being monetary damages claimed by the applicant against the respondent jointly and severally for their physical, mental, emotional, psychological, and other damages suffered by the applicant as a result of the infringement of applicant's fundamental rights. Hey, I guess I'm perceiving that this has more to do with, I just feel that maybe Bruce Finn must have told them to look, you need to apply, do some sort of application. Let there be some sort of suit, already filed suit, so that from there he can pick it up and continue it in the international scale. Now, with all this happening, they actually mentioned the fact that his clients have medical issues and they're insisting that he should choose the hospital of his choice in Nigeria where he should have medical attention. There'll be so many prophecies here and there concerning his health and the fact that, but whatever the case is, they should ensure that Nnamdi Kanu is in the best of health position. Honestly, we have too many issues in our hands in the country. We don't need Nnamdi Kanu's issue at all to the already fragile unity that we are still managing. Anything that happens to Nnamdi Kanu is going to be a different ballgame. I'm sure it's out.